Cohen was still in the custody of the Bureau of Prisons. It was just a different location that he was within custody, meaning a different location at his home. The judge says in response, quote, "We're not talking about locations. That's a false issue. We're talking about the issue of retaliation. He was put on furlough with no conditions other than hang around your house and be in your neighborhood. The only condition. And when it came time for the furlough period to end, he was allowed to stay outside without any conditions other than that. All of a sudden, when the Bureau of Prisons understands that Cohen is writing a book and will likely finish before the election time, he is imposed with conditions. The probation officer doesn't give him a form, the form for home confinement that typically is used by probation. The judge says, quote, "What purpose would there be in a paragraph 1 of this agreement preventing engagement with the media, TV, print, film, books, prohibiting social media platforms, no posting on social media, communications with friends, not to do certain things about publication?" The prosecutor says in response, quote, "The probation officer is just trying. He never drafted an agreement like this." The judge, "I have never seen such a clause. In 21 years of being a judge and sentencing people and looking at the terms and conditions of supervised release, I have never seen such a clause. Have you, Ms. Rovner, ever seen such a clause?" Ms. Rovner, the prosecutor, quote, "I have never seen a federal location monitoring agreement, Your Honor." The judge, "Why would the probation officer ask for something like this unless there was a purpose to it? Unless there was a retaliatory purpose saying, you toe the line about giving up your First Amendment rights or we will send you to jail. We are not going to negotiate about it because if you negotiate, we're going to send you to jail and call you intransigent. How can I take any other inference other than it was retaliatory?" Prosecutor, Ms. Rovner, "The officer had no knowledge about Mr. Cohen's book." The judge, "It's impossible to take that inference." And then, new character in the scene. Mr. McKay, who is a different prosecutor, gets into the mix here. "Your Honor, this is Thomas McKay. Can I just jump in with a factual point on the timeline?" The judge, "Mr. McKay, is Ms. Rovner not capable of answering my questions?" Mr. McKay, "She certainly is, Your Honor." The judge, "You will keep quiet. And if Ms. Rovner wants to consult you, she may. One person speaks on a side." The judge then says, quote, "There is no purpose that I can discern from this paragraph 1 that I can find in any term or condition of a supervised release that I have seen in 21 years of being a judge. Nor is it feasible to believe that the probation officer wasn't asking for something like this because he had some instruction about something like this. I cannot believe fairly that there was not a purpose in paragraph 1 of the location monitoring agreement to stop his exercise of his First Amendment rights." And that's my